This is Allie Johnson of Smart Move Real Estate in Edmond, Oklahoma, reading the Oklahoma Real Estate Commission's residential contract. I'm going to assume that you are listening to it on audio and not reading it along with me. I have read previously the first page, Acknowledgement and Confirmation of Disclosures, and that is available on a different YouTube link. Each of these pages will be a different link so that you can listen to them in sequence on a playlist, and you can modify the volume and the speed of playback usually in the bottom right hand corner, as well as the quality of the video. It is being recorded and should be available in HD for you. All right, let's jump into it. Here is the Oklahoma Real Estate Commission's uniform contract of sale of real estate for residential sales. At the top, there's the property address, and then we start with the form header, Oklahoma Real Estate Commission. This is a legally binding contract. If not understood, seek advice from an attorney. The header is Oklahoma Uniform Contract of Sale of Real Estate, Residential Sale. First paragraph, contract documents. The contract is defined as this document with the following attachments. Check as applicable. There's two columns. The first column on the left reads conventional loan, FHA loan, VA loan, assumption, seller financing, a blank for you to write in. The second column contains single-family mandatory homeowners association, condominium association, townhouse association, supplement, sale of buyer's property presently under contract, and sale of buyer's property not under contract. Second paragraph, parties. The contract is entered into between fill in the blank for seller and fill in the blank for buyer. Third paragraph. The parties' signatures at the end of the contract, which include any attachments or documents incorporated by reference with delivery to their respective brokers, if applicable, will create a valid and binding contract which sets forth their complete understanding of the terms of the contract. This agreement shall be binding upon and inure to the benefit of the parties hereto and their respective heirs, successors, and permitted assigns. The contract shall be executed by original signatures of the parties or by signatures as reflected on separate identical contract counterparts, carbon, photo, fax, or other electronic copy. The parties agree that as to all aspects of this transaction involving documents, an electronic signature shall have the same force and effect as an original signature pursuant to the provisions of the Uniform Electronic Transactions Act, 12A, Oklahoma Statutes, Section 15-101 et sequente. All prior verbal and written negotiations, representations, and agreement are superseded by the contract, which may only be modified or assigned by further written agreement of buyer and seller. The parties agree that all notices and documents provided for in this contract shall be delivered to the parties or their respective brokers if applicable. Seller agrees to sell and convey by general warranty deed, and buyer agrees to accept such deed and buy the property described herein on the following terms and conditions. The property shall consist of the following described real estate located in blank county, Oklahoma. Subparagraph number 1, legal description. 4 lines of blanks for your legal description, and at the bottom it says property address, city, and zip. Below that, together with all fixtures and improvements and all appurtenances subject to existing zoning ordinances, plat or deed restrictions, utility easements serving the property, including all mineral rights owned by seller, which may be subject to lease unless expressly reserved by the seller in the contract, and excluding mineral rights previously reserved or conveyed of record, collectively referred to as the property. Paragraph 2. Purchase price, earnest money, and source of funds. This is a cash transaction unless a financing supplement is attached. The purchase price is fill in the blank, payable by buyer as follows. Within 3 days of the execution of the contract, buyer must deliver blank dollars as earnest money, which shall be deposited into the trust account of blank, or if left blank, the listing broker's trust account as partial payment of the purchase price and or closing costs. Buyer shall pay the balance of the purchase price and buyer's closing costs at closing. If the buyer fails to deliver the earnest money within the time required, seller may terminate this contract or exercise seller's remedy under paragraph 15 or both by providing notice to buyer before buyer delivers the earnest money. If the last day to deliver the earnest money falls on a Saturday, Sunday, or legal holiday, the time to deliver the earnest money is extended until the next day that is not a Saturday, Sunday, or legal holiday. Paragraph 3. Closing, funding, and possession. The closing process includes execution of documents, delivery of deed, and receipt of funds by seller, and shall be completed on or before blank date, closing date, or as such later date as may be necessary in the title evidence paragraph of the contract. Possession shall be transferred upon conclusion of closing process and unless otherwise provided below. There's a blank line. In addition to costs and expenses otherwise required to be paid in accordance with the terms of the contract, buyer shall pay buyer's closing fees, buyer's recording fees, and all other expenses required from buyer. Seller shall pay documentary stamps required, seller's closing fee, seller's recording fees, if any, and all other expenses required from the seller. Funds required from buyer and seller at closing shall be cash, cashier's check, wire transfer, or as determined by the provider of settlement services. This ends page 1 of 6, OREC Residential Sale Contract, last modified January of 2019. Check out the YouTube channel for other links in the comments to other videos.